Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann. Shauna Sanford will be joining us again next week. The last episode we talked about wills, trusts, and estate planning with Carole Neff. Attorney Carole Neff joins us again today as we explore successions, probate, and what happens when you're gone. So stay with us, because when we return, Attorney Carole Neff joins the show to share what you need to know about successions, probate, and what happens when you're gone.
I am for the child who lives in motels, cars, and shelters, now in foster care, a group home, where he sleeps not on a bed, but on a temporary cot. He is the child I am for. I am a CASA volunteer. I am you.
Hello, everyone. Welcome back to the show. We welcome back Attorney Carole Neff today. She is an authority in estate planning and succession. She has, in fact, co-authored a 3-volume reference series for lawyers. She is board certified by the Louisiana State Bar Association in those areas. So thank you, Carole, for joining us today.
You're welcome. Happy
just
to
like
be
with
here.
the estate planning episode and writing wills, a lot to cover. So let's start. Define for us, what is successions?
Well, successions, a succession, which I guess would be a noun, would be the term we use to describe what the assets of a deceased person are, what the liabilities are, and that's basically what the succession is, what the deceased person owned and owed.
And so today we're going to talk about what happens after the passing, after someone's gone, what happens. And in connection, this 3-volume series you wrote, maybe we could put that up on the screen. Why don't you tell us, what's this all about?
Well, that's been out for about 20 years, and I've co-authored it with my partner, Max Nathan Jr., and it really is not a treatise that your audience would want to own. It's really written for the practicing attorney and the CPA, and it's really how do you plan an estate, what are the documents, how do you draft them, how do you administer a succession, what are the pleadings, how do you draft them. It's really a tool for practicing lawyers.
And that was obviously a gigantic undertaking. How long did it take you to prepare?
Well, the first manuscript took a year and a half, and then we update it every single year. It's in its 2nd edition, and we have a love-hate relationship with it. It's a labor of love, but we have to keep it up to date, and so it's in a loose leaf format. So we're right on top of all the changes in the law constantly.
Yeah, and it's a very highly regarded treatise. I know that other attorneys who practice in your field actually spend good money to have that book at their elbow, at their
we hope
close
so,
by.
yes.
So, and you have to update it every year because laws change regarding
Laws change
successions.
constantly. Federal law changes. Louisiana law changes. So we write about those changes, and sometimes that changes how the documents are prepared. Sure. And so we're constantly revising it.
All right, well, let's get right to the topic then. So when you're talking about successions, you often hear the word probate court. How does that relate to this topic?
Well, the probate court and the probate process is where the court does assist in the process of transferring those assets to the parties who are supposed to receive it. So probate applies when somebody has a will, and that would be the court assisting in dispersing the assets to those who are named in the will, if the will is valid. It also is the process when someone dies without a will for the court to participate in identifying who the proper heirs are, who's entitled to receive, and that process to distribute the assets to those individuals.
And for those who didn't tune into the last show where we defined wills, a will is where and it's a very special document. You have very special steps to have a valid will. That's where you define, when you're the will writer, what you want to have happen to your estate, what you own, all your assets when you die.
That's correct.
And if you don't have a will, the law determines what happens. And
correct.
Basically, it goes to family and whoever's closest, your children first.
And it also defines what powers and rights people have with your assets.
Okay. And so probate court is, or probate is the process whereby all the things on the checklist are checked. Do we have a valid will? Are all the heirs properly receiving their portion? Sometimes if you're a forced heir, in Louisiana there's forced heirship, certain children of a certain age, or unless they have physical or mental limitations, they're required to get part of your estate too. Probate court checks into all that?
Yeah, and actually that is what the probate process is all about, to identify the assets, to determine what liabilities there are, so that at the end of the day, when the estate is closed, the distribution is to those who are really entitled to receive.
Okay. Now, who do you go to when someone has passed away and let's say they have a will or they're not sure if there is a will, who do they go to for help in getting the succession open and getting the probate started?
Well, they would go to a lawyer that does succession work, and hopefully someone who specializes in the successions.
Right. And you could go to Joe Blow or Susie Blow, who practices everything, including, tax, immigration, whatnot, but you run the risk, because the area is so specialized, the safest course is to go to a lawyer who practices exclusively or almost exclusively in successions and estate planning.
And yes, indeed, and that doesn't always cost more. Mm-hmm. Sometimes you have so many efficiencies from the person who specializes in it that it costs less than when you're paying someone who really doesn't work with it all the time.
Sure, because you know how to do it like you know the back of your hand, and therefore you don't waste time learning the process, and you don't waste time doing the wrong steps.
Exactly, and we have paralegals that work with us who do a lot of the legwork, and they're billed at a lower hourly rate. It can definitely save on cost.
So when you have someone who's passed away in your family and you need to go see a lawyer to help out with this, how does that lawyer get paid? Do they get paid out of the estate of the person who died? Do they require payment up front? How does that work?
That varies from lawyer to lawyer, but the obligation to pay is the estate's obligation. Okay. So it is the estate that pays for it out of the estate assets. But if the estate is insolvent, there's more debt than there is assets. Sometimes there's an issue, and some lawyers are going to require some upfront funds. Yeah, it depends on who handles it.
And the estate is just one of those terms of art that means everything that the person died in possession of.
Correct.
Assets and debts, correct?
Correct.
Okay. And if the lawyer can be paid out of that, then maybe the surviving spouse, children, they understand that they may not have to front the cost.
Correct.
They may, depending on the lawyer they work with.
Correct. And even in terms of fronting the cost, if they're allowed to get access to the funds of the deceased person, then they can use those funds to pay for the cost. Okay. And normally that's how it is done.
Right. And if there is liquid assets or cash in a bank account or a CD that could be cashed out, the court can give approval without many delays, assuming there's no hitch.
Correct. And even in some estates, and the majority of states now in Louisiana, can appoint a succession representative to be independent of the court, and we've been able to do that for the last 10 or 11 years. That allows someone to be able to access those assets without having to keep running back and forth to court to get court approval to do that.
Yeah. The use of trust in succession. So we talked about briefly in the last show how trust can play a role in planning, in writing your will and preparing for your passing. What happens if there's a trust in place during a succession?
A lot of people are creating living trusts to avoid probate. And there are certain states where it's very, very popular, and it was something that actually didn't even work in Louisiana until the last several years. It works in Louisiana, these probate avoidance trusts, but in Louisiana we have such a simplified independent succession administration now that there's really no reason to have to do, for most people, to do a living trust to avoid probate, but many people have those living trusts, and what they do there is they actually title all their assets while they're living to this trust, and they have to live their financial life out of this trust, and it's the trust that transmits the assets, distributes the assets, not the court.
And just so we're clear, you use the term a living trust, which is not such an obvious thing to use these days in Louisiana for the reasons you just gave. Let's not confuse that with a living will.
Yes, and people do use those terms and think it's the same thing, but it's nothing the same. The living will is the document where people are specifying that if they're in a permanent vegetative state, that they don't want to be on life support.
It gives your directives, your orders. If you become incapacitated and you're beyond saving, you're just, like you said, in a vegetative state, a coma, that gives authority, in fact, directs people to pull the plug.
Pull the plug, or
don't
plug
tell
in
them
at
don't
all.
pull the plug.
Or don't put the plug in at all.
Right.
Yes.
Okay. Now, in a succession, you have debts and burial expenses. Or maybe there's cremation expenses if there's no burial. What about those costs? Do those come out of the estate too?
Those come out of the estate, and the burial costs are considered the most important. So there are priorities. If the estate doesn't have enough money to go around, the first thing really that gets paid is the burial expense.
Right. So if you die and you've got a big debt on your credit card or several credit cards or whatever on a card that you bought that's still money is owed on it, burial expenses come ahead of all those.
That is correct.
Okay.
First in line.
And
the lawyer's fees too, for handling the estate. Because without the lawyer, you
then
couldn't.
Who's going to agree to handle it if you don't know that you're going to get paid?
Exactly.
How do insurance and taxes? If you could give me a minute and a half answer on that.
Well, we talked about wills and people writing their wills, but if they have life insurance, it's really not the wills that control where that life insurance goes. The life insurance is going to go to a designated beneficiary with the contract that you have with the insurance company. And if somebody...
So the proceeds from a life insurance policy, if you have a life insurance policy on you and you pass away, but you direct that your wife or your cousin or your best friend gets the benefits, they're the beneficiary, that's not part of the estate. It's
not part of the estate. It doesn't go through the probate process. The will doesn't control it. The judge doesn't have any power over it. And the nice thing for in some estates, especially the insolvent estate, the beneficiary is going to have those proceeds, and those proceeds won't be responsible for paying the deceased person's debts.
Right. So what about taxes? How do taxes?
Well, taxes, there are all kinds of taxes.
Death and taxes are certain in life. How do taxes go with? Do taxes go with death?
Yes, it does, but not. Louisiana no longer has an inheritance tax at all, and the federal government has increased the exemption for federal tax to a very, very high level. So the only those people who have assets over $5,250,000 have a federal estate tax to pay. So if we have a $10 million estate, the first $5,250,000 is going to be exempt from tax, and the amount over that is going to be subject to a large tax.
But with proper estate planning, you might be able to avoid some of those tax consequences if you have such a large estate.
Correct.
Okay.
Through lifetime giving, use of trusts, and so forth.
Excellent. Well, we're out of time for this segment, but please stay with us, because when we come back, we will answer some of your questions on successions.
We never forget our best teachers, the ones who do so much more than teach. They inspire and insist we bring our best in everything we do. We find those mentors in our Catholic schools. It's why Catholic school graduates consistently go on to college, land better jobs, embrace faith, and lead. Louisiana Catholic schools, in a class of their own.
Welcome back to Power of Attorney. We're talking about successions, what happens after you're gone. And we've reached the part of the show where we answer your viewer questions right here on our show. So let me get right to it. Liz writes, can I represent myself in court for a succession? What if my siblings are lying about what my father's wishes were for his will in probate?
And I think Liz's question means, can I represent myself in court as perhaps as an heir in my father's succession? And the answer is yes, but sometimes it is desirable or advisable for Liz to have a lawyer represent her. It depends on what the issues are. Right. And what if her siblings are lying about what her father's wishes were for his will in probate? Doesn't matter what they have to say. That's why there's a will. And if the will is validly drawn, they can say anything at all about what their father's intentions were. But if the document is drafted correctly, then the father's wishes are written in the will, and that controls.
Right. What if, and I remember from my days 20-something years ago in court, occasionally you'd have a fight where someone said that somebody had undue influence and they forced this elderly parent to write a will or to put something in a will that person really didn't want to have in the will. When you contest or you challenge a will, what happens if you believe that you think the will was something that was done sort of under duress, or the elderly person was taken advantage of and convinced to write a will that's not exactly their real intentions?
Well, if that's what you believe, you have the right to make that claim and to present evidence to show that that is correct, and you have the right then to attempt to knock out the will if it was done under undue influence.
In fact, what often happens is someone writes a will and then the children say, the testator, the person who wrote the will, was not mentally sound at the time of the will. You have the right to challenge that, too.
You have a right to challenge capacity, and if they can prove that the person who signed the will didn't have proper mental capacity to understand the nature of the dispositions, that's a way of knocking out a will.
Right. You can't just give your personal opinion. Usually you need to have some evidence, a doctor to give medical opinion based on the condition of the patient being treated before he died, or things of that nature, correct?
Yes, and the kind of medication that person was on, but a lot of times it involves testimony of people who have been around that person at that time.
And if it's notarized, the presumption is the notary doesn't notarize anything without verifying that she's talking to a person who is aware of where he is, what day it is, who's the president, things like that, correct?
Yes, and that's one of the reasons why it's important to get the will properly drawn and to have the right representative putting that together to make sure that the will stands up as a valid document.
Okay. Karen writes, can I choose one particular person to distribute my assets in probate? That's obviously when you're writing your will, correct?
Yes, and the answer is yes, and that person that you name is going to be called an executor or an executrix, so absolutely that's one of the advantages to writing a will, is that you have the right to pick who you want to distribute your assets.
Excellent. Now, Tom has a question. What if a father had a child he does not know about when writing the will? How would that affect the will? What rights would that child have to any part of the estate?
Well, if that child is under the age of 24 when the parent dies, then the child would be a forced heir. But the child has a burden when it's the father who died, because the child has the burden of showing that that really is my father. If the father didn't know he had a child, then probably the father's name isn't on a birth certificate. Maybe it is, maybe it isn't. But there's still a time limitation where the child or someone acting on behalf of the child, the mother of the child, brings an action, it's called a paternity action, to establish that this is indeed the father of this child. There's a 1-year time frame. So
1 year from the date of death?
1 year from the father's death, or 1 year after the child turns 19, whichever comes first.
Wow.
So if it's a minor,
comes first.
Then usually it's the mother of the child who would assert the claim that this is a child of this deceased person, and here's my lawsuit, and here's my evidence, and that's when sometimes DNA becomes important evidence.
Right. Another question from Ed. If my grandmother died in the late 1990s and my grandfather died recently, can we open the succession for both of them simultaneously?
Yes, if the grandmother died first and her succession was never opened, absolutely you can open both successions at the same time, and you can do them as a joint succession.
Excellent. So Ruth writes, can you sell your possessions or liquidate assets of something in your will to use or sell while you are alive?
Absolutely. The will doesn't become effective until you die. You have complete control over your assets. You may want to address what happens if you wanted to leave a possession to a certain individual. You might want to think through and have the will address what happens if I've sold it, because maybe you want the proceeds of the sale to go to that individual, but you don't lose the right to control those assets, liquidate them, do anything you want with them if you've written it into the will.
And I assume that it's the same answer even if you have children who would be forced heirs. You can sell off parts of your estate while you're alive. You could be a terrible manager of your property, in effect. The law doesn't prevent you from running your estate while you're alive the way you wish.
Absolutely, that's correct.
So a forced heir gets a forced portion, a piece of the succession, if they qualify as a forced heir, simply depending on what's left over in the succession, correct?
Yes, and there's sort of a yes but in that answer too, because sometimes the forced heir has the right to go back and see if the parent had given away assets to avoid the claim of the forced heir while the parent might be on a deathbed, giving away assets to reduce the size of his estate to avoid the claim of the forced heir, or to limit the claim of the forced heir. So the forced heir is going to have certain rights to actually go back and see what happened prior to death, and possibly fictitiously add those assets back into the estate to make a claim.
Okay, here's another question, and it follows kind of a similar topic. What happens if I want to disinherit children, assuming that they would otherwise be a forced heir? Is there still laws that allow you to disinherit?
Absolutely, absolutely. If you have, well, for one thing, if you die without a will, all of your children are going to inherit automatically. So you have to have a will to be able to disinherit a child. But if the child is under the age of 24 when you die, you can only disinherit them if you have grounds to disinherit them. And typically, the only real relevant ground that people are able to use is if the child was estranged from the parent and refused to communicate with the parent for at least 2 years after becoming an adult. And then the parent would have to write a will that said, my son, John, after turning 18 years old when he was an adult, refused to communicate with me for at least 2 years, and therefore, and he didn't have any just cause for not communicating with me, he knew where I was, so I'm going to write this will and disinherit him. Even though he's a forced heir, he didn't communicate with me for 2 years, I write him out of the will. Wow. That's possible.
And when you say communicate, what if they send hate mail? That doesn't count, right?
That would not count.
Okay. All right, well, we have another question here. Cindy says, can I make a condition in my will that says to an heir, when you die, you must leave a certain amount of money to A, B, and C persons?
That you can't do. But once again, if your goal is to let someone use assets so that when that person dies, then the assets go to A, B, and C, we can do that with the use of a trust. So maybe in this question, instead, the answer is no, but we can set aside certain assets and give your heir the use of it, the income from it, a usufruct over it, and then when you die, when your rights terminate, your use and your usufruct terminates, then A, B, and C would get the assets.
Wow. Well, here's an excellent question. Suppose I die and I owe a lot of money. Do my children inherit my debt?
No. If the estate is insolvent, and I actually just had a recent situation with this where the father died and he owed more money than he had in the bank, and the children had to make a decision on whether or not they were going to take care of these bills, or should they just walk away, and the decision was made that they're going to walk away, and the creditors can come and make whatever claims they can, but there was nothing to be gained for the children of the deceased person to open the succession, to take possession of anything. But under any circumstance, they would not be responsible for anything more than what they inherited. So if they got the $3,000 bank account, and then the creditors saw that they had found out that they had the $3,000 bank account, the creditor can get them to kick back the $3,000 bank account.
Right, and whatever they might inherit, that's subject to the expenses of the succession.
Correct.
Lawyer fee, so that's deducted first, the burial costs and legal costs, correct?
Yes, but fortunately their own personal assets that they owned outside of the deceased person are not at risk, and that was actually a change in Louisiana law about 15, 20 years ago. It used to be that if you took possession of any asset of the estate, everything you had was subject to the claims of the deceased person's creditors.
So if there was something that had great sentimental value to it, but not
monetary.
Any real monetary value, you couldn't take that without taking on all the debts.
Exactly,
Wow.
but that's not Louisiana law anymore, so you're not at risk for anything more than what you received.
Right. Well, one thing that occurs to me is we mentioned in the last episode about community property. If one spouse dies and that spouse has a lot of debt, and it's debt incurred while the two were alive and while they were married, how does it work if the surviving spouse, if she maybe is living in a house, she's co-owner of property, does all the community property go towards paying debts?
And it could very well, the answer is it could very well, because if we're talking about community assets, we're probably also talking about community debt. So the surviving spouse owes, let's kill off the husband first, the surviving spouse being the wife, the surviving spouse is obligated to at least one half of the debt. So that can be very difficult for a surviving spouse.
Let's jump back to estate planning. Some people actually get life insurance policies where the beneficiary is the estate to avoid an estate being in debt and having a surviving spouse also be made poor, if not homeless.
That is an option, but it's not always the best choice.
Okay.
Because in that case, now the creditors can get some of those life insurance proceeds. If instead the insured named the surviving spouse as the beneficiary, she can walk away with those proceeds and at least his half of the debt she doesn't have to satisfy out of the insurance. She's still responsible for her half of the debt,
right,
but his half of the debt, the life insurance does not have to satisfy. So sometimes the planning would be better not to pay the estate.
Well, and I guess the moral of the story then is, God forbid you're taken from this earth anytime soon, if that stitch in time that saves nine, if you do your estate planning, if you figure out what you want to do to protect your loved ones from unpleasant circumstances, there are things such as life insurance policies, there's trust, there's other things that you may be able to do to limit tax consequences and to maximize what might be left out of your estate for your loved ones.
Absolutely.
Okay, and estate planning lawyers such as yourself, succession lawyers such as yourself, and those who do what you do are the best people to talk to.
It's our job to hear the client, to interpret what they want, and see what we can do to carry out their goals as best we can.
Thank you so much. That's, again, another excellent show on this topic. We are
welcome.
out of time, so please remember to visit the show online at John Redmann POA, where you can watch the previous episode with Ms. Neff. You can watch any other episodes. You can get all kinds of useful information about your rights. So you can find us on Facebook, follow us on Twitter. We love to hear from you, so keep sending in your questions. Thanks so much, and we'll see you next time on John Redmann, Power of Attorney.